All right, everybody, we are going to get started here with our Wednesday webinar today. It is our Q&A webinar, which means, again, that you get to submit your questions in advance. We do these, the goal is to do this once a month. Just questions about elder care issues, asset protection issues, aging issues in general. And my job is going to be to answer them as best as I can. All right. So before we do get started, though, let's go over our housekeeping, if you don't mind. I did share this last month, but I figured it'd be better if I just put it up on the screen. So this is an educational presentation. It's not legal advice. My answers will be, they have to be general in nature. I can't speak or answer your specific issue because I'm not representing any of you in this webinar. Here we are just as an educational presentation. The event does not create any type of attorney-client relationship. And if you are a client of the firm asking a question, you could always just call us up or email anyway. But if you're here asking a question, just know that there's not going to be any attorney-client confidentiality for any questions because this is a public setting. So hopefully that makes sense. But if you do need specific legal advice, feel free to call the office. And we offer free consultations either in person or on Zoom, okay? I'm just getting a buzz here. All right, so as I always like to begin, let's make sure that you can see me and hear me and of course see my screen, although I'll be getting rid of the screen shortly. If you could just let me know in the chat or the Q&A that you can see me and hear me. All right. And the answer is good. Thank you. Okay, so I'm going to stop sharing the screen here because we covered our points. Great. Thank you, everybody. All right, now you just got more of me. So the first question that we're going to try to work on today is, and again, like I said, we've got a bunch of questions. Some of them have 2 or 3 or 4 parts, so I don't know if I'll get to all of those subparts because, again, we have a lot of questions and I want to get to as many people as I can. So first question from a gentleman named Ron. My mom, who needs to be in a care facility, we'll assume nursing home facility, is just over the amount of money she's allowed to have because of different assets such as cash value in her life insurance. Is there a way to reduce the cash value to help her receive Medicaid? Well, as we work with clients every single day, and there's a lot of Medicaid information that we've put out there. Our webinars, for one, we've been doing them for over a year. If you want to get any specific information as to the different Medicaid benefits or programs or eligibility changes, we've done webinars on those. Just go to tullyelderlaw.com, click on videos, and under there, webinars will be a subcategory, and you can look at specific presentations just on Medicaid. But Ron, to help you at this point, Medicaid eligibility is about 3 things. It's about the applicant's, in this case, mom's assets, her income, and her care level. Okay, and again, if we're talking about specifically about her assets in a nursing home, an applicant for Medicaid benefits within a nursing home, what's called chronic care Medicaid, is allowed to have $15,900 in assets. That's not income, that's not per year, that's not per month, that is money in the bank, which also includes non-qualified investment accounts, non-qualified annuities, CDs, checking, savings, as well as cash value within a life insurance policy. So whether it's cash value, Ron, in a life insurance or just 20 grand in the bank, it's too much money to establish eligibility for chronic care nursing facility-based Medicaid. Now, the first thing we look to when we're looking at a client with too much money is how much is it? And again, I don't have the specifics on that, but if it's a $25,000 number and we've got to get down to $15,000, what we certainly look at is where can it be spent or transferred in an exempt way. For example, if there's a spouse, assets can be transferred from one spouse to the other without any type of Medicaid penalties whatsoever. If there's a disabled child, for example, assets can be transferred to that disabled child as exempt, without any Medicaid penalties being implemented. Assuming we don't have either of those scenarios, and there's others, what we look at is how can we spend it in an exempt way. The most common way is to prepay funeral expenses in what's called an irrevocable pre-need funeral agreement. So you would go to the local funeral home that you would believe your mom would want to be at and literally pay for everything in an irrevocable pre-need contract. That would be an exempt way to get a small amount spent. By small, I mean $10,000 to $15,000 funerals these days. And that way you can get her below the 15. If it is a greater amount of money, then you may be looking at a strategy called a promissory note and gift strategy. That is a rather complicated but very, very useful asset protection strategy when we're looking at a nursing home scenario in a financial crisis, meaning we have too much money, but we need Medicaid. So the promissory note and gift strategy, in a nutshell, is where we roughly protect a portion, say 40 to 50, maybe 60%, depending on the variables, but we protect a portion and we spend a portion. The promissory note strategy typically comes into play if we're looking at tens of thousands of dollars over the allowed amount of the 15.9. So if we're at, perhaps it works for 60,000, perhaps it works for 70,000. It all depends on the variables. But there are ways, Ron, to actually get her below that number, either gift it to an exempt person, spend it in an exempt way, or use it, be able to implement the promissory note and gift strategy, which of course we do quite frequently, all right? Next question, this is from Lisa. Now, there's a bunch of points in here. I'm gonna summarize it as best as I understood it. It looks like your father-in-law passed with an IRA, all right, an IRA account without any beneficiaries. Now, when there are no beneficiaries on an IRA account, or an annuity for that matter, or life insurance for that matter, that asset has to go through the estate, okay, through a probate proceeding. Now, depending on the amount of the asset, if it's greater than $50,000, you are looking at a full probate proceeding. If you are looking at less than $50,000, you can pursue what's called a small estate administration, which is meant to be a simplified, less expensive, less time-consuming administration of the estate when you have minimal assets. So, and I do believe that's the situation as you lay out here. Now, if there's no will distributing that money as to who inherits it after a court proceeding, then intestacy would kick in. And intestacy states that money would go to spouse and children. If there's no spouse, then it goes to children. If a child is deceased, then a portion would go down to the grandchildren, okay? It's just how the law requires it to occur. And it seems like you're saying that the investment company didn't do it that way. So that's confusing, and I don't know why they would not do it that way. So I would need you to go talk to the investment company and have them explain that. It doesn't make sense to me as to why they would give it to one child versus all of the intestate heirs, all right? So that's something to follow up with them. If they did pay it out to the one child, surviving child, and not another child, and not children of a predeceased child, again, I think you need to dig a little deeper. IRA benefits are always going to be income taxable. So whoever does withdraw from an inherited IRA, there will be income taxes to answer. All right, now that answers your question as best as I'm able to at this point, Lisa. All right. Then we have Deborah. Again, a several part question. I'll do the best I can, Deborah. So what it looks like is mom had an irrevocable trust that it appears owned the house, all right? Now, typically an irrevocable trust would say, upon my passing, sell the house or distribute the assets to my children. It looks like the house was sold, and at the closing, the cash from the closing would then go into the trust directly, and the trustee has to distribute those assets pursuant to the terms of the trust. You do not, as a trustee, just want to make the payments and distributions out to the beneficiaries of the trust. You always want to properly close the trust. And there are two ways to close a trust, or to close an estate for that matter. And the first is what I call the formal way, which is going to the court and pursuing what's called an accounting proceeding, where you get your expenses get approved by the court, what you've done with the finances gets approved by the court, and you are discharged. That takes time and a lot of money. So there is another way to close a trust or an estate, and it's what I call informal, where we utilize a written agreement within the family, and it remains private. It's faster, it's less expensive. It works fine as long as everybody is agreeing and cooperating. And the name of the agreement is what's called a receipt, release, and refunding agreement. And it's and again, this is how you should close a trust or an estate after the person has passed on. And the purpose of this is for the beneficiary to acknowledge they've received their portion. That's the receipt portion. Release, meaning they are releasing the fiduciary. They're releasing the executor or the trustee, saying, I'm not going to pursue any claims against you. You did a fine job. So the trustee, who's actually the client at that point, can literally close the chapter, all right, and not have to worry about liability arising later. And the third part of the agreement deals with refunding. So again, receipt, release, and refunding. Refunding is where if a bill was unknown and all of a sudden it lands in the trustee's lap, each of the beneficiaries are agreeing to contribute back to the trust or to the trustee to pay the bill or to pay the bill directly. Again, it's the proper way to close the trust. If you just make distributions from the trust without an agreement like this, there's going to be open ends and there's not going to be understanding among the parties. Now, again, looking at your question, Deborah, if you are the only beneficiary and you wish to make distributions to other people in the family, you can do that. Generally, it should not be coming from the trust because the trust does not call for that. The trust perhaps leaves everything to a singular beneficiary. Once that beneficiary takes it in, then they can make gifts, all right? There is a federal gift tax which can be considered. There is no New York gift tax. The federal gift tax has two parts. It allows a person to give $15,000 per person per year without having to file papers, without having to file a gift tax return. But the other part of it is what's called a lifetime exemption. And the federal gift tax lifetime exemption is directly tied to the estate tax exemption. It is one and the same. So the federal government says you can give it away while you're alive or you can give it away when you pass away. It's currently about $11.6 million. So if a person gave $200,000 to their neighbor, yes, it's over the $15,000 annual gift tax exclusion, but it is way under the federal gift tax exclusion, the lifetime one. So that person should talk to their accountant and see whether they should file a gift tax return, okay? So hopefully that was helpful. And last point of your question, Deborah, is yes, there are what's called statutory commissions. The law allows within statute for an executor or a trustee to be paid a certain amount of dollars based on what they're doing, unless the will or the trust says the trustee or executor is not entitled to any commissions, okay? So there is, again, a statutory commission provided it's allowed in the governing document. All right. All right, from Maureen, excuse me one second here. Okay, so, sorry, I'm back. All right, Maureen, needing some assistance with your aging husband, a very common scenario, and vice versa, of course, but and there's an age difference as well. What you're looking at is, according to your question, that you're working full-time and your older husband, his health is declining, and you're afraid of leaving him at home for longer and longer periods of time. Entirely understandable, and again, very, very common. Gratefully, there is, as I shared in the first part, there's two Medicaid programs. The first one I spoke about was the nursing home Medicaid program. Generally speaking, we don't jump to that program at all. 99% of my clients, including family, are like, I don't want to go into a nursing home unless I have to. Nursing homes are very, very important. They serve a great role, and most of them do a darn good job. But ideally, you want to stay home as long as you can. And that sounds like it's certainly your situation, Maureen. Now, Medicaid also has what's called community Medicaid. That is where they can send an aide into the home to help your husband with what are called the functional activities of daily living: walking, bathing, toileting, dressing, grooming, eating, transferring, getting up and out of bed. It's literally everything we do in the morning, right? We get out of bed, we walk to the bathroom, we use the bathroom, we bathe, we toilet, we groom, we get dressed, we eat. So those functional needs, those activities of daily living are what Medicaid can help with. They're not there necessarily for medical needs, okay? When we have a need for a doctor or rehabilitation center, an ER, those are medical needs, and generally Medicare is there to pay for them. What we're talking about here are custodial or chronic care needs. mostly called long-term care needs. And again, that's the ADLs. So certainly there are ways to make a spouse eligible. As I mentioned earlier, assets count, income counts, and the care needs count. So the assets have to be below a certain amount. We can work on transfers to an irrevocable trust if that's appropriate. We can work on transfers to children if that's appropriate, or just transfers to you as the spouse. On the income side, we utilize a tool called a pooled, P-O-O-L-E-D, supplemental needs trust. That is a godsend. That is a fantastic tool. Nothing's perfect, but it's a great tool to shelter excess income and use that income to actually pay that living expenses. All right, they'll pay any bills in your husband's name, which again is a great thing to shelter excess income. And then on the care side, there will be different assessments that New York State will require. The way we do it, and the way that we're very different from every other elder law firm out there, is we practice what's called elder care law. So yes, I have the attorneys, and yes, I have the paralegals, but I also have geriatric social workers on staff, and they are there to help with the care needs. They will coordinate benefits, they will coordinate providers, they will coordinate the care. They'll intervene if there's any type of crisis. They will continually be assessing the situation and, most importantly, advocating for your husband and supporting you during the process. So over here at Tully Law Group, the attorneys and our advocates, or care coordinators, as we call them, work as a team. It's literally all hands on deck. We meet once a week just to talk about our families that have engaged us in this way. By the way, it's what's called life care planning. So our life care clients are those that have the full team available and helping with the legal matters, the financial matters, and the care matters. In my book, there's no better way to really navigate the elder care continuum, okay? So hopefully that was helpful. As an aside, but equally as important, you wanna make sure you have your legal documents in place, a very comprehensive modified power of attorney being probably the most important, and the other ones, of course, we could talk about. All right, so Maureen, please feel free to reach out if you'd like to talk more about it. So thank you. Karen, we're in our 60s, late 60s, and we have 2 children. Basically asking, should we be doing an irrevocable trust? Should we be planning and protecting for the future? You're welcome, Maureen. So the general idea is yes, Karen. There was a time a number of years ago when we were sitting with everybody over 70 and saying, it's time to start protecting your assets for potential long-term care in the future. We now do that with everybody at 65 years of age. Why? Because we have on the horizon a new look-back period for what's called community Medicaid, as I was just describing in the prior question. We always and historically have had a 5-year look-back for nursing home care. And home care, where the aid comes in, like I just explained, was one where we could literally protect all of our assets in July and be eligible in August. There was no look-back period, or there still is no look-back period for home care. And no look-back period means no penalties, no waiting period. But that is going away. And again, plenty of webinars on our website, tullyelderlaw.com, that talk about the coming changes for community Medicaid. In a nutshell, January 1st of 22, there will be a new look-back period for home care. It'll eventually be a 30-month look-back, resulting in penalties, just like a nursing home scenario, okay? So the idea is, because of these look-back periods, to undertake your planning and your protection as early as you are comfortable in doing that. Again, 65 and above generally seems to be the consensus age as to when this advanced asset protection planning should be undertaken. We provide a service called Elder Care Protection Planning. That focus, the foundation of that type of a plan, that type of a service, is going to be an irrevocable asset protection trust. Irrevocable trust has frightened clients in the past. They don't like the word irrevocable, but the good news is the way this type of a trust is prepared for our clients, a lot of flexibility. You keep a lot of control. You can sell your property if you like. There's no negative tax ramifications as long as it's all done properly. So the irrevocable trust is almost like it's not there, especially when we're talking about just the home going into it. If there's other assets to protect, then there's different things to talk about. But still, there's control and there's flexibility kept within the parents. So I would say yes, the answer to your question is yes, you should be speaking with us or somebody like us to get in place an asset protection plan. When we do it, just like our life care work with Medicaid, I like to take that extra step, and I like to let the client know and show the client that we're here for the balance of their lives as they age. Even with an elder care protection plan, we go and offer to go year to year. So if we're hired July 14th to help with family protect the assets and put together the plan, we're available for a full year. So any questions, any changes, all included. We offer a funding meeting to talk more about the trust and what goes in it. We offer an annual meeting to sit with the client and the trustee, make sure the trust is being operated properly. So again, it's a very comprehensive service. And yes, I think you should consider it based on your question. All right, so thank you. Now, Lisa, a couple points there. Lisa, I'll answer what I can. I hope you understand. First question is, a person is on Medicaid, can they give gifts to family members? And if yes, what's the limit? You do say cash gifts. Cash always becomes a little bit fuzzy because it depends on where it came from. But the general rule, Lisa, is that if somebody's on Medicaid, they should not be making gifts anymore. Now, in community Medicaid right now, there's no look back, there's no penalties, but that's all changing in January, all right? And in 2022, there's going to be a recertification application looking back, and we don't know yet whether 2021 gifts will be looked at in 2022 during the annual recertification. And it's just easier to keep things clean when you're dealing with Medicaid. So the general rule is do not make gifts if you're on Medicaid, okay? Second question, if a person is moving from one nursing facility to another, you do say or assisted living, so I don't know what you mean by that, because Medicaid does not pay for most assisted living. So let's stick with the idea of a nursing home here. Does the Medicaid status change to long-term? I'm not very clear on your point there, but what I can gather from it, Lisa, is that the person is in a nursing home. If they are already approved for Medicaid, that is long-term care Medicaid. That is chronic care Medicaid. And yes, they can move from nursing home to nursing home. I wouldn't do it during the application process. You'd want to do it once the application is approved so that the numbers don't get messed up, so to speak. If it's a spouse, it's easier. If it's an individual, you got to be a little more careful. You're asking about the intent to go home, to return home, right? So a strategy we use when we have, so that means to me it's probably a single individual, not a spouse. So an intent to return home is a very useful device when we have a single person who owns a home and they need to go into a nursing home. If the goal is for that person to actually get home, then we get back home, then we can file this document called an intent to return home. That is the person saying that I don't want to stay in this nursing home forever, which is probably the case for most people. For some of those people, it's possible they can go home. For others, maybe not. The subjectivity of it doesn't matter for the filing of that document. You can file an intent to return home. And what that does is it shelters the house from Medicaid and from them actually putting a lien on the property. If somebody goes to a nursing home without an intent to return home, that house becomes an asset, becomes a resource, and Medicaid can put a lien on it, okay? So the intent to return home is a very helpful tool to prevent that from happening for a period of time. I cannot give you a black and white date as to when they will start to ignore the intent to return home. It's generally 6 months. And after that period, the house can have a lien placed on it. It's a rigmarole, but they can do it, okay? So that's the risk. Most families, when you're looking at an intent to return home and a nursing home placement, will be looking to sell the house. Now, generally speaking, if you file an intent to return home, you shouldn't be selling it. So those things generally don't happen at the same time, but you put the house on the market as soon as possible afterward. You go to the closing, hopefully Medicaid has kicked in during that time frame. And then when the cash proceeds come in, then you're going to have that promissory note probably that I mentioned earlier. That would be the asset protection strategy when we're looking at nursing home Medicaid and we have too much money. Okay, so hopefully that helps. Terry, a couple questions. I'll do what I can. So there's an IRA out there There's no asset protection in place. Husband does not qualify for long-term care insurance. That's understandable. Income from the IRA will be paid out in the future, assuming the required minimum distributions are being handled otherwise. If the husband requires chronic care in the future, including a nursing home, will that income be subject to claim by the nursing home since it belongs to her? So I'm trying to read here, Terry, is that the spouse or the Medicaid applicant? Okay, so husband requires nursing home. So again, going back to Medicaid eligibility, assets, income, and care. The husband's income, if that's the one that requires the nursing home, it is his income that is going to be subject to the $50 limit when we're talking about Medicaid eligibility in a nursing home. Her income is generally excluded. We can use a spousal refusal on excess income, doesn't protect it entirely. Medicaid has the ability to insist on a portion of it. But most of the time, depending on the amounts, what you're looking at is $3,259. That's the amount that a community spouse can keep while the husband is in a facility, okay, on Medicaid. Now, if the community spouse is under that 32 number, they can receive a portion of the husband's income to bring them up to the 3259. The husband's income balance will then go to the nursing facility. If the community spouse, wife in this case, is already over the 3,200, then they're not going to get any of the husband's income whatsoever, all right? And the spousal refusal, again, will be a good tool to utilize to shelter the wife's income. A caveat, spousal refusal is not a permanent save. It is a temporary Band-Aid, and it's worth doing, but there will come a time in the future, once the husband's Medicaid application is approved, that the wife, the spouse, should be doing her own post-eligibility asset protection, okay? Difficult to shelter income, but at least she could shelter the assets. Next question. You're welcome. Next question. There's an IRA. Is that extended to a beneficiary as far as creditor protection? The answer is no. So if mom has an IRA, that is protected because it's her IRA. If she passes and leaves it to her daughter, that is an inherited IRA. It is not protected from creditors. Now, in a nursing home and did not have beneficiaries. So if a Medicaid recipient has an IRA, that IRA is allowed to be kept in addition to that $15,900 account we spoke about earlier. IRAs are exempt. They're exempt provided they are in payout status, meaning the RMD, the required minimum distribution, sometimes to be maximized, is paying out annually to the Medicaid recipient in the nursing home. That counts as income. And again, the general rule when you're looking at a single individual in a nursing home is $50 is kept, health insurance premiums are kept, and then everything else goes to the facility, okay? Now, there's also another risk out there, you guys are hitting them all today, called estate recovery. Estate recovery is when an individual on Medicaid passes away with assets left in their name solely. One of the most important things for a person on Medicaid and their spouse if they're married is to avoid probate, okay? Especially for the Medicaid recipient. If you avoid probate, meaning joint accounts, beneficiary accounts, or use of trusts, then there's nothing in your name solely. There is nothing, therefore, in your estate. Medicaid does have, just like every state, the ability to recover against the estate of a deceased Medicaid recipient. The way New York defines estate are those assets, not joint, not beneficiary, not trust, but those assets that are in their name solely going through their estate. An IRA without a beneficiary will have to go through that person's estate and would then be taken by Medicaid. All right, so that's a risk, and that's certainly out there. Question from Donna. I'm going to get a sip here, excuse me. All right, so Donna, you and your sisters are concerned about dad. He's nearly 80. He's in okay health. Are there negative aspects of him not having any type of will or trusts? And the answer is absolutely yes. Will a handwritten document of his intentions hold up legally? Probably not. You want somebody like me to look at the whole situation. You want to deal with the 4 basic planning documents, and then you want to consider asset protection, equally as important. A last will and testament and then a durable modified power of attorney, probably the most important basic document there is. Without a power of attorney, or without a power of attorney having the proper modifications built into it, the family can be thrust into a guardianship proceeding if there is no capacity anymore. So the power of attorney is worth its weight in gold as long as it's the right one, okay? You go to LegalZoom, you go to your real estate attorney, you go to the criminal attorney, they may not, probably not, are going to have the right power of attorney with the right language in it that deals with aging and asset protection and income protection and Medicaid. All right, you go to somebody like us, we will make sure that power of attorney gives the agent, the children, the child, all of the power they need to help legally, financially down the road, okay? So again, 4 basics: the last will and testament, durable, modified power of attorney, healthcare proxy, and living will. Downside to not having them is primarily is if capacity is lost, you're not going to have a financial decision maker. You're not going to have somebody that can protect the assets. On the healthcare side, New York State does have what's called the Family Healthcare Decisions Act, that allows a child to make decisions for the parent if there is no healthcare proxy. But when you have 3 children, it's nice to be able for the client to pick who they want to make the decisions first. Sometimes the oldest is not the best one to make the decisions. Sometimes the middle one is. So with the healthcare proxy, the parent can pick which one's first, which one's second, perhaps which one's third. Now, the idea of asset protection, if he owns assets, a house, 100 grand, whatever those assets are, there should be a thoughtful discussion about asset protection. I will say hands down 100%, if there's a piece of real estate that should be protected. Financial accounts, it depends how much. If it's only 20 grand, then no, we don't have to get crazy with the asset protection. You still need the basic 4 documents. But the greater the amount of money, the greater need for protection. If there is no asset protection in place, and if care is needed, care is very, very expensive. So you're probably going to rely on Medicaid to pay for it. And nursing home care has that 5-year look back, which causes penalties, which means the family may have to pay for the care themselves. In a nursing home, that's $15,000 to $20,000 a month if this is done too late or not done at all. In a home care setting, like I've shared, we're free and clear right now. There's no look back period. There's no penalties for Medicaid applications in 2021. But come January of 2022, then he's going to have the same problems as if it was a nursing home, okay? So 100% get the planning done, get the protection done, all right? We'd be happy to talk to you guys and, of course, your dad about it. Thank you. Another question, joint accounts. So I've shared a couple times that a joint account is helpful to avoid probate, which is a court proceeding you want to avoid when somebody passes on. It's helpful in that it gives a trusted child the ability to write checks, pay bills, transfer, protect. So joint accounts, generally speaking, are helpful as long as you've got the right person on there. There's always a risk, though, when you're putting a child on your account. And there's always a risk if you're giving assets to a child, okay? In general, real estate should never go to a child outright, God forbid, no security, tax issues, a lot of problems if the house goes to a child. The house should always go into an irrevocable trust. But if you give cash to a child or make them joint on your account, what's going to happen is any problems that your child has, all right, and I call it the Ds, death, divorce, debt, dementia, or all the other illness, doing something dumb, okay? Spending it when they shouldn't be spending, not being prudent with the joint account money. The child's problems can become the parent's problems. So you have to be careful who goes onto the accounts. It's the right one, that it's not just based on age, it's not just based on gender. These are business decisions. And I encourage our clients to always pick the right person. I don't care if it's the youngest daughter or the oldest son. It's gotta be the right person that's financially responsible to be able to be on joint accounts and hold money, okay? Hopefully that, again, was helpful. Ben, and we're running out of time here. So Ben, okay, in your 60s, married. What steps, if any, can we take to protect my pension, my wife's accounts? So if I become disabled, can the government take all or any part of my pension from my spouse? So kind of the theme of what we've been talking about is the idea of asset protection. You want to protect your assets. I didn't say income. As I share with families, there's Medicaid eligibility, assets, income, and care. I can't do anything about your care now because you're still younger and healthier. Income, I cannot do anything about your income for the most part, especially Social Security and pensions, because you do not yet need the care. I can shelter the income up to certain reasonable amounts by the use of what's called a pooled supplemental needs trust when there's actually time for care, all right, when it's the time for care. So you don't do that now. If you need long-term care in 10 years, that's when you do the Medicaid work. That's when you do the pooled income trust or pooled supplemental needs trust to shelter the income. We've sat with clients with $8,000, $9,000, $10,000 a month in income. That amount of income can be difficult to shelter. We sit with a client with $2,000, $3,000, $4,000, $5,000 a month. It's a little easier to shelter in the home care scenario. As I've said already today, in the nursing home scenario, you're not protecting it, all right? You're looking at the $50 a month. The balance goes to the nursing home, unless if the spouse's income is very low. Other than our residents, what type of property should be included in our trust? Great question, Ben. The irrevocable trust is an asset protection trust. And the way I share it with our clients is we always want to keep a percentage, an amount of money outside the trust. Retirement accounts never, ever go into a trust. They must remain in the individual account holder's name. But if we have $200,000 in it in a bank account or an investment account, we can talk. Does some of that go into the irrevocable trust, or do you leave it out? Irrevocable trusts, just by their very nature, have to limit access to the client in order to gain the asset protection. So you can't put your $200,000 in the bank into the irrevocable trust expecting to use that to pay your bills. That's not how it works. If you have access to the money in the trust, then so does Medicaid. So we have to limit the amount that entirely the amount that goes to you. We can't allow that to happen at all. We always build in a back door so assets can go from the trust to children. All this is to say you always leave a good chunk of money outside the trust. There's generally no formula. You could look at your budget for the next 5 years and say, I want to keep X out just in case, or it's just a gut feeling. How much do I want to keep out to have that sense of comfort and security that I don't have to talk to my kids about getting money back, okay? So it's a balancing act, and we do help with that. As I shared earlier, in our elder care protection plan services, we do provide a funding meeting or a funding call so we can balance out what goes in the trust and what doesn't, all right? Hopefully that was helpful, Ben. Kigo, all right, now, her question is, if there is a pooled supplemental needs trust, and as I've shared, that is the tool we use to shelter excess income in a community Medicaid setting. There's different points that I always share with clients as to how that works. One of those points is, if you don't use it all, you can lose it, okay? So again, big picture is, in a community Medicaid setting, a Medicaid recipient is allowed to keep $904 a month. They are allowed to keep health insurance premiums, for example, their supplemental, ARP, whatever, supplemental or secondary coverage. Let's say that's $300, using a round number. So the Medicaid applicant is allowed to keep the $900 and the $300 for a total of $1,200, but their income is $2,000. So you then have an $800 surplus, or overage, as we call it. The way to shelter that is to have that client join a pooled supplemental needs trust. Again, generally the only way to protect income in a community setting. That pooled income trust or supplemental needs trust will then pay the bills in that client's name to help keep them in the community. They charge a little fee. They'll only pay bills in that person's name. They don't pay for anything medical in nature, and there is the risk of losing what you don't spend. Gratefully, under current law, in the example I just gave, $1,200 is kept, $800 is put in the pooled trust. Let's say they can only spend $600. So there's $200, net the little fee, of course, $200 left over every month. Under current law, that rolls over month to month to month. And it is still that applicant's, that Medicaid participant's income through the pooled trust. They will pay any bills in his name, legal fees, accounting fees, prepaid funeral, home repairs that are legitimate contractors and estimates and contracts and so forth, car payments, mortgages, real estate taxes. But the lose it risk is that if or when that client ultimately passes, if there is a balance in that pooled trust, it is lost. It does not go to the family. It does not go to us. It doesn't go to the executives at the pooled trust. It goes to the charity itself. These pooled trusts are run by charities. So that is the beneficiary of any money remaining in there on the day they pass away. Okay. Now, the new law that's coming out in January, they're trying to mess with that a little bit. We're hopeful that that portion will not be implemented. There's discussion and threats, if you will, that New York State may penalize any money left over. So it may not roll over and accumulate. We're hopeful with all the advocacy that's happening and lobbying that there will be no provision like that come January. Okay, so hopefully that resolves what you were looking at there. Power of attorney. All right, I got 3 more questions, 2 more minutes. How can a power of attorney agent best protect stock assets for an incapacitated parent applying for Medicaid without creating a conflict of interest? You're right. A power of attorney can have a conflict of interest. They are a fiduciary. They have to put the parent or the principal's best interests before their own. And in my book, depending on the totality of the circumstances, that does not preclude assets being transferred to the power of attorney agent, if that's what's in the parent's best interest. Okay. If you're doing it as the power of attorney agent to benefit yourself, then that's the conflict. That's what's not allowed. So I think, again, but depending on the circumstances, it can actually be done. If there is a beneficiary on the account, then the money can be held with the written understanding that that's where it goes. The money should be available for the parent. It's their money to spend. It's their money to use. And there can be a family agreement or some other understanding for that beneficiary to have security, to know, comfort, to know that whatever is left in that account after dad needs it can be available to them. All right. Again, it gets a little tricky, but you got to look at all the circumstances, and it usually can be done. Okay. Hopefully that helps, Cliff. Norm is asking how to determine the monthly amount of income the community spouse can keep when we have a spouse in a nursing home. I alluded to this a little bit earlier. So let's say mom is the community spouse. She's at home and she's got $2,000 a month in income. Dad is in a nursing home and he's got $4,000 worth of income. The dad in the nursing home is allowed $50. We'll just keep it simple and say 50. He has $3,950 too much that can go to the nursing home. However, mom is entitled to what is called a minimum monthly maintenance needs allowance. Minimum monthly maintenance needs allowance, MMMNA. That this year is $3,259. So if mom's only at $2,000, she is entitled to $1,259 of dad's income, okay, to bring her up to the MIMNA. And then everything else that's the balance on dad's income is paid over to the facility. Okay. So hopefully that helps. If mom's already at the $3,259 or over it, she does not get anything from dad. David asking, any updates for applying for Medicaid? So depends which Medicaid, David. So nursing home Medicaid is still sitting at 5 years. The last time we had a change to that was 2005, 2006, but it is 5 years for nursing home applications. Community Medicaid, of course, is the one that is going to have the problem and the changes. Come January 1st, there will be a new look-back period for Community Medicaid for all applications filed after January 1 of 22. The initial look-back period will go in reverse to October of 2020. And it will be phased in month by month until we hit a maximum look back of 30 months, 30, okay? So what we're sharing with clients at this point is get your applications in. If you have a need, right? If you have that long-term care need, get that community-based Medicaid application in 2021 before the look back period begins, especially if you're protecting assets. Okay, those are the questions. I am very grateful for all of the opportunity to answer all these questions and to interact with you all. Look forward to next month, okay? But don't jump ahead too far. Next Wednesday, we're having an evening webinar on spousal estate planning, dealing with the estate taxes. You're welcome. All right, so join us next Wednesday. Get on our email list. Again, go to our webinar page. You can just enter your email there, and you'll certainly receive emails of our new and upcoming webinars. We're trying to do these things weekly. We're going to do the best we can. All right, again, thank you. And everybody stay safe and enjoy the summer when the sun comes out. It's almost out. Thanks. Bye-bye. You're welcome.